everyone. Today I would like to discuss about the Sarfaesi Act, that is the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, which was effected from 21st June 2002. This act was necessitated to speedy recovery of the secured loan. Whether the borrower takes a loan by mortgaging the property, it is a secured loan. This act is a draconian act. The secured creditor may enforce the security interest created in his favor without any intervention of the court or tribunal, but such creditor in accordance with the provisions of the act. So the lender, that is the bank or financial institutions, have a right to recover the loan, and there are some processes that if the borrower fails to repay the installment or secured debt, then the secured creditor, that is the bank or financial institution, may classify his loan account as NPA, non-performing asset. That is, when the borrower fails to make payment of the installment or repayment of the secured debt within 90 days, then the financial institutions or the bank, that is the secured creditor, may issue the notice, which is called the demand notice under Section 13, subsection 2 of the Sarfaesi Act, to repay the entire loan amount by the borrower within 60 days. This is the demand notice. After getting the demand notice, the borrower has the right to raise or make objection or representation against the said demand notice. On receipt of the demand notice within 15 days from the date of receipt of the demand notice, the bank has to reply while the rejection of the objection is made by the bank. If the bank fails to reply within 15 days from the date of receipt of the said objection or representation, the bank will be in awkward position. That is, the further steps under Section 13, subsection 4 of the Securities of the Sarfaesi Act, bank would not be able to take any measures under Section 13, subsection 4 of the Act. At that stage, the borrower or guarantor or any aggrieved party don't have any right to file any case, whether before the DRT or any court of law. After issuing the 13-2 notice, the demand notice, the bank will issue further notice after expiry of the 60 days from issue of the demand notice. The bank will issue possession notice under Section 13 of Section 13, subsection 4 of the Sarfaesi Act, read with Rule 8, Subrule 1 of the Security Interest Enforcement Rules 2002. Bank will issue the possession notice under Rule 8.1 of the rules. The notice, bank will affix the said notice to the conspicuous part of the secured asset, that is the mortgage property, and bank will also deliver that possession notice to the borrower. And within 7 days from date of issuing of the possession notice, bank will have to publish the said possession notice in 2 leading newspapers, one in vernacular language, which has sufficient circulation in that localities. At that stage, the borrower or aggrieved party may prefer an application under Section 17, subsection 1 of the Sarfaesi Act before the learned DRT of having the jurisdiction. And in that case, the borrower can raise all the legal points in the application. After that, bank may apply to the district magistrate having the jurisdiction of the mortgage property, in which jurisdiction the mortgage property is situated, district magistrate or the chief material magistrate, as the case may be, under section 14 of the SARFAESI, bank will apply for taking physical possession with the order of the district magistrate. In that case also, after receiving the order of the landed district magistrate or landed chief metropolitan magistrate, the borrower or aggrieved party may file application under section 17 subsection 1 of the SARFAESI before the landed DRT having its jurisdiction. In that case, after filing the application under section 17 subsection 1 of the Sarfaesi Act, the borrower has to file a put-up application for stay or set aside of the order of the landed district magistrate. Even after that, the bank can proceed for sale of the property. In that case, bank has to issue notice under Rule 8, Sub-Rule 6 of the Security Interest Enforcement Rules 2002. The first notice has to be issued for 30 days sale notice to the borrower. The notice has to be delivered to the borrower, and it has to be affixed on the conspicuous part of the property under Rule 8, Sub-Rule 7 of the Sarfaesi Rules, and that notice has to be published in 2 leading newspapers, one in Mortgagor language, having sufficient circulation in that localities under Rule 9 of Sub-Rule 1 of the Sarfaesi Rules. In this stage, if the aggrieved party, borrower, guarantor or mortgagor may prepare an application under section 17 subsection 1 to the DRT having its jurisdiction, and after filing the application under section 17 subsection 1 of the before the landed DRT, the borrower or aggrieved party may file put-up application before the landed DRT for stay or set aside the sale. These are the procedures have to be followed by the borrower or aggrieved party, and bank has to be followed by the Sarfaesi proceedings for recovery of the secured loan. That's all. If any inquiry, you may contact to the phone number even and WhatsApp number also. Thank you.